Thanks, I appreciate it.
That was not.
Sorry.
That
Very good.
sounds like bullying to me.
I know, it was.
That's a term
taking
of
offense.
endearment.
Okay, we're here today to talk about Stotler 2 property. We came across our desk as an email. It's being submitted for a revised preliminary plan. And if you remember, Stotler 2 property is out on Mounts Road. It was part of one of the properties that were part of the consent agreement back in the lawsuit back in 2000, 2004, 2005. So the property has finally, I guess, getting to the point where it's sold, and I believe the developer now is Ken Campbell and Greg Burling, and they're looking at, I forget how many.
371.
371. They do not like, I guess, or they're asking to move away from the cluster development. It was zoned or planned as a cluster development, and they're moving away from that and submitting to the zoning department for a new preliminary plan. And I've got some drawings here showing that. And Bruce and I talked earlier last week.
Not the zoning department, the planning department.
Wasn't it zoning? It's not going through rezoning? No, it's just a preliminary plan that it's going through. That's correct. And so Bruce and I talked a bit last week, and we thought this would be a good opportunity to sit down and revisit this property with the board. And because I think Bruce has a couple questions in regards to how to proceed forward. At this point, we need, the Water and Sewer Department needs to give feedback to Planning Commission as far as the conditions for service. So we wanted to revisit sewer service to this property. Probably discuss, Bruce, you probably want to discuss a little bit about the agreement that was reached with the developer, because there are certain terms and conditions in that agreement that Bruce probably has concerns about and wants to bring to the board's attention. Bruce, at this point, I mean, I can walk them through the changes in the plan. We have the original plan, preliminary plan. We can show those drawings. We can also show the proposed plan. I've got information on the agreement.
I'm just pretty pumped up. I've heard about this lawsuit for almost 5 years now, so
Oh, wow.
I'd really like to dig right in and understand where we are, Bruce. This is super exciting for me.
Do you want me to lay some more of the groundwork as far as like sewer service out there and where this development is at and some of the agreement?
Yeah, you can show them that, but let me interject here and say, I promised Pat South about 30 minutes ago, and she had a good line. She said, Stotler 2 is like a bad penny. It will not go away. And I said, we're revisiting that bad penny today.
Yeah, she asked me, what's going on over there? I said, you're not gonna believe it. Guess what?
Gotta shine that penny up. That's right. So what you have here is a map showing our eastern service boundary for Lower Little Miami. Okay. Boy, that doesn't show up at all.
Yeah, I don't think it shows on there,
It does
Chris,
not
like
show.
Yeah, I
So-
think the point, you have to use the mouse maybe, right, Martin?
Anyways, well, let's go back.
Actually, if you want to walk over to, you can take the microphone with you.
I'm going the wrong way. Nope, that's still not right.
So you hit the little thing on the left side of the screen? Oh, yeah, there you get it.
Let's get back over here. Sorry, this is taking me a second. I'm not used to this pad.
It's awkward.
Try again, get back over here. The kids would make fun of me.
Doing way better than I could.
See if this works now. Okay. This is, getting back to the map, this is the map of our eastern service area boundary. What you see is going north and south is Zoar Road, and then we have Foster and Mainville Road to the south. Stotler is, obviously, Stotler 2 is the property here, and then this service boundary for Hamilton Township, the urban service boundary for Hamilton Township back in 2000, comes down Zoar Road and then cuts across here. When the agreement was made, we ended up taking the service boundary, keeping that service boundary. The 2000 urban service boundary is our service boundary, but we included Stotler 2 and the other subdivisions. Thank you. The other subdivisions that had approved preliminary plans at that time. So Stotler 2 had an approved preliminary plan. Wellington Estates had an approved preliminary plan, and Wellington Glen here had an approved preliminary plan.
So they've got an approved plan with an approved amount of total units, but it was how those units were set up in cluster versus larger lot kind of a thing?
Yeah, you're gonna see, and I'll show it to you here in a minute. Well, Chris is gonna show it to you. It's really not much difference. I mean, it was hideous back then, and they've shifted it around a little bit, but there's not any difference in the number of lots. Residential lots are still the same,
Yeah,
371
300,
is the proposal.
So it's just the layout of the hideousness that it's
Trying
still.
to, yeah, I thought it was gonna be something a lot nicer. It actually is less green space by about 12 or 13 acres.
That's correct.
And it just changes the street configuration, puts some cul-de-sacs in, and Chris can go through it.
So, yes, so this is the 2005 approved preliminary plan, which is based off a cluster, some type of cluster design zoning that Hamilton Township had. And you see clustered areas of homes, and you see open green spaces between those clustered areas.
And this is, and again, this is a good history lesson and refresher for me even, that this was all thought in 2003 and 4, coming up to that, and then there was a court case. Then, even though this was outside the service area, but yet they had a plan submitted, so the court said you have to accept this plan, something along those lines. Is that not the
Yeah,
case?
I'll go through that in a few minutes,
Oh,
but
okay.
that's pretty close, yeah.
And then they want to transition from this approved plan here to this revised Stotler 2 preliminary plan.
And that's the same number of units
This is the same number.
with
of
less
units.
green space?
Yes, actually, it does have less
Yes.
green space.
It's just
Yeah, originally it
disgusting.
was about 70 acres of green space is my understanding, and this one is about 58.2.
Who's doing this development?
Ken Campbell.
Yeah, Ken Campbell.
Well, Ken's involved. It's a sole asset LLC. It's Greg Birding, and I think that is Fisher slash, what's their, Grand Communities. I think Fisher out of Fort Mitchell, Kentucky is Greg. And then Ken's either probably the manager or maybe he's a partner in this sole asset LLC. The other thing this doesn't show, and if you want to hear from me, what brought this to our attention, and I'm going to first go back to the 2000s decade where Warren County, predominantly the RPC, but sometimes the commissioners were involved, it was a decade of litigation where there was a group from Hamilton Township that called themselves Vision 2000, and they were all about slowing down growth. And they started participating in the public process of coming to RPC meetings, county commissioners meetings, encouraging the county commissioners to slow or stop growth in Warren County. And we had one particular commissioner, probably goes without saying his name, but that thought we could just close the doors and stop growth in totality. Which, by the way, he got sued for personal liability in the lawsuit we'll talk about in just a minute. Anyway, part of that process also related back even further than that, and I don't, I don't want to cast aspersions, but the way this county operated from a water and sewer standpoint was we had a sanitary engineer, which was Chris's predecessor, and he pretty much had a standing agenda item on the county commissioner's docket every Tuesday. And when he brought something forward to the county commissioners, my perception was they just went along with it. You know, he was the expert and they just went along with it. And at some point, it started to catch up with us because the Lower Little Miami wastewater treatment plant was running out of capacity, and that became an issue, and we've since fixed that. And when I talk about this court case and some of these provisions in it, you have to put it in a context of that's where we were. We were out of capacity. We had overpromised in approving preliminary plans through RPC, the approval of all these potential lots that could be developed in Warren County, but we didn't have capacity at our plant to treat sewer for all those lots. And we had a study done by a professional consultant, and that contributed to all this. But because we started to
And
see.
if I can interject, and that's where the board's philosophy was using that as, I don't care what we've promised in the past, there's no more room at the end, we're not, you can't have it, and we're not going to expand it. That's right when I came in, and Pat and I went and expanded the Lower Little Miami treatment plant. So that's what created anything to where even the ones that were approved had capacity.
And so because of that history in a nutshell, what we did process-wise at the county level that Chris has sort of alluded to, and I wanted to explain it to you, was we came up with a process that when a preliminary plan came in, back in those days called a preliminary plat, and the law changed, no distinction, one and the same thing. A process that when a preliminary plan came into the RPC executive, or to the executive committee, but first filed with the staff. The process was staff was to circulate it to our departments for comments, especially the sanitary engineer. And they've continued to follow that process, and sometimes they're pretty mundane, and there's no reason for Chris to write a letter per se. But during that era, when that process got initiated, the sanitary engineer would write a letter to the RPC and tell the executive committee for their meetings, hey, we're out of treatment capacity, or no, we can do this, or we can't do that. And that's where we are and why we're here today, because planning took in a plat, or a revised preliminary plan for Stotler 2, and one additional property I'll mention briefly in just a moment. But then I said, well, you guys got to send it to the sanitary engineer for him to comment. And then I contacted Chris and I said, Chris, we need to go and meet with the commissioners and find out where they want us to go on this. You have 2 seats, you have 2 votes, you have designees that go to those RPC executive meetings, as you know. However, and what I told planning to do is how we started structuring these things in the past was, you can put in your staff report and recommendation, if you think that some preliminary plan, should be, you recommend approval with a list of conditions. They always do. The list of conditions can have in it, subject to sanitary sewer being available as approved by the Board of County Commissioners. And one of the reasons we did that was Planning Commission during that era got sued one time, different lawsuit, for $5.5 million. It was a pretty legitimate claim. We settled it in the litigation through mediation. It was a substantial settlement, so it had merit. It wasn't just somebody's throwing something on the wall to see if it would stick. And after that, through my assistance, I tried to get planning to go out and find greater insurance liability limits, an umbrella policy or something, and they couldn't find it. So they only have about $1 million worth of coverage, and when you get sued for in excess of $1 million coverage, you have to really be concerned. And since they couldn't find that, so one of the ways that we structured that was, well, one thing we can do is we can just, because it's not RPC that says you can't have sewer it's the commissioners. So you pass that buck along, and keep it rolling through the process. It doesn't delay the developer, they don't incur damages, and so on and so forth. So, with all that being said, it recently was sent to Chris for him to submit a letter, and I said, Chris, before you do that, we need to see where the commissioners are on this. Okay. Two different things. One is in 2004, not 2005, the Board of County Commissioners held a public legislative hearing to determine whether to modify the boundaries. And if you would go back to the map. Of the lower, yeah, go back to the one, no, let's go back to the other one. I'd rather use it, then you can use whatever map you want to. So Zor Road, we always talk about Zor Road as the line of demarcation. Just to orient you, 22 and 3 is up here, and you turn right if you were headed east, down to Zor Road. And then you had this little old goat trail that went through here called Mounts Road. It used to come straight through here. So this is all changed because of this development. The county commissioners back in those days had a boundary of, for its sewer improvement area that didn't follow the roads. It went out into parcels and it identified all the parcel numbers, but the line of demarcation was offset to where you had properties that had sanitary sewer within the boundary on part of their property and the rest of it did not. And in 2004, the Board of County Commissioners, through a public hearing process, major turnout from that part of the county of people that said we have property, vested property rights, we're entitled to have sewer on our property. There was some litigation, I'll mention that briefly in just a minute. And then the county commissioners reduced the line to follow the roads, okay? And it was just a black and white, here's a map and here's where the boundary shall be. In 2005, after the study was done, and let me mention the lawsuit, one of the property owners, which was probably here, contested that. And I don't know why, one of the largest respected law firms in Ohio, maybe even the nation, Vorsater, Seymour and Pease, represented them, the Columbus office, and they filed it as an administrative appeal. I still scratch my head today. Why did they do that? And we filed a motion to dismiss, and we got it dismissed. And then it never came back around in the 2005. Things were slow. This was being developed, and you remember what happened in 2007, 2008. The housing market just went flat, and nothing ever happened. In 2005, the county commissioners had another legislative hearing to evaluate whether to modify that resolution from 2004. And the county commissioners did modify that resolution. And Chris had it up there. You can go back to it if you want to, and it's highlighted that the section is applicable. And they made an exception. After the consultant study was done, we realized, at that point, we knew how many units that had been approved, lots had been approved that had preliminary plan approval, and then we knew what our capacity was. We did a very short moratorium, even though that was not recommended by me, but they did it anyway for a short time, and they lifted it early, only, I think, after 6 months. But the difference between the 2004 and the 2005 resolution is this paragraph that's highlighted, and it made an exception. It said, here's your map, follow the roads, and that's the boundary, except property owners and or developers with final and or preliminary plat approval, now called preliminary plans as I mentioned, that have substantially relied upon such approval and have made improvements should be allowed access to the public sanitary sewer system if sufficient system and treatment plant capacity is available to serve the additional connections at the time the property owners and or developers make application. So this exception came about. Same time, there was a preliminary, and I'm going to call it preliminary plan so you don't get confused, and that came to the Planning Commission, and that was for what's called Stotler 1 and Stotler 2. Now go back to your map. Stotler 1 and Stotler 2 Take your mic. Stotler 1 is down in the corner. It was a development that was done by Dixon. It's called Eagles Point. Have I got that right?
Was it Providence or Eagles Point?
Eagles Point. Providence is on up here, and we're at Mounts, and part of Stotler 1 was down here. It was only about 65 acres approximately.
Eagles Point, yeah.
Yeah, right in here, 65 acres here that the Stotler family owned, Bill and Sylvia Stotler. And then they owned down Mounts Road. There was no connectivity. Stotler 2, which is 171 acres. The Planning Commission, after being lobbied, is that a good way to say it? Bullied was a word I heard earlier by Vision 2000 group, and a particular county commissioner denied the Stotler 2 plat for 171. And Chris showed you a picture of it a moment ago.
Can we pull it up?
Yeah, you can do that. Well, leave it there, I'm going to use that, but that's it, and I said, that's the 2000 revised preliminary plan. Had 171 acres laid out, and 371 lots, and it looked like an army barracks. I mean, it was hideous. The property owners filed a lawsuit. The Greater Cincinnati Home Builders Association intervened in that lawsuit. So we had good law firms. We had KMK that was representing Keating, Muthing, and Kleekamp representing Stotlers, as I recall. HBA was Aronoff, Rosen, and Hunt. So we had good lawyers involved, more local lawyers out of Cincinnati. And the case went to court, and the magistrate made a decision, and here was the rub. In those days, the Planning Commission's subdivision regulations didn't say a whole lot, not like what you see today. And when the plat got denied, the state statute and the subdivision regulations say if you deny a preliminary plan, you must state with specificity the grounds and cite the subdivision regulations of which you deny that plat. Well, all worked up emotionally, they deny it. Bob Craig was the executive director, just talked to him accidentally a couple days ago. And Bob calls me the next day and says, what am I supposed to put in this letter? What am I supposed to say? And I said, is there anything in the entire code, the subdivision regulations, that help us? And he said, the only thing is the purpose clause. The purpose clause, okay, well, if that's all you got, go with it. It didn't go very far. The magistrate said that doesn't work. You can't rely on a purpose clause. Judge Flannery upheld the magistrate's decision, and the plat got approved. We appealed. We were represented by a firm that I'm now with, Shorter Mondro Barbier and Powers. We appealed that, and then I went to the executive committee and got their approval, and I went to Judge Flannery and I said, this down here is a no-brainer. We are withdrawing our appeal. Well, before it even got appealed to the 12th District, before he made his decision, we're throwing in the towel on this. We only want you to make a decision on this. And we knew what it was going to be. And he said, you lose. The magistrate got it right. So at that point, the appeal happens. The case is on appeal to the 12th District. We had really no leg to stand on. Our legal precedent was, and Commissioner Grossman and Adam in the room will appreciate this, like a 1968 Court of Common Pleas case that got published. How many times does a Common Pleas case get to publish? That was our basis. So with RPC's Executive Committee's permission, I started negotiating with Joe Trouth on Stotler 2, and a settlement came about. And that's where we still have this settlement today, but you're going to find out the settlement in context is what was going on in the 2000s decade, not what's going on now. And you're going to have to make some decision about that because of those factors. So if you move to the
Hey, Bruce, can I just stop you for a minute just to make sure I'm understanding where you're
been to
heading,
jail.
heading here. So your point about the context being different is now RPC has subdivision regulation, there's a whole lot of, not just the litigation, but now there is subdivision regulation and changes that have been made over the last 15 years that bring us to a new context.
That plus what I'm getting ready to read you.
Okay.
I wrote this. I mean, we all negotiated back and forth, but I wrote this. And in the case, to settle and resolve the case, because we had lost, we had this very weak appeal, nonetheless a pending appeal that got dismissed pursuant to the terms of the settlement agreement. The settlement agreement provides that the RPC will apply the subdivision regulations in effect May of 2004. That's when the preliminary plans for Stotler 1 and 2 were presented. And accepts the approved revised preliminary subdivision plat for Stotler 2 as attached here to, subject to conditions set forth in the staff report, and I think there were 24 conditions, which is typical of what we do. Then I put this provision in, and the developer at that time, not the same folks, it's changed hands many, many times. The Stotlers have long been deceased. They were called PBM. And it says, PBM shall have 24 months from the signing of this full and final settlement and mutual release of all claims to submit a final subdivision plat for Stotler 1. They probably timely did that, because that was going to be first. And shall have 36 months to submit a final subdivision plat for Stotler 2. All they would have had to have done is plotted one lot on a plat. That's all they didn't do that. They had until November 9th of 2008. They had 3 years to do that, and they didn't. So the 2005, which I gave you a copy of, that preliminary plan has expired. It's no longer on the books. The other provision that's relevant is under the chapter, because in this lawsuit, the county commissioners, because they controlled sewers, were a party. And in their official capacity, as well as one commissioner being sued individually. And it says, in light of, and this is under the county commissioners in Warren County agree on their behalf, typical lawyer language, to authorize their legal counsel to execute a stipulation of dismissal, typical lawyer language. And then when you get to the meat of it, it says, in light of the court's decision, and it cites the case number, where the magistrate ruled against us, Judge Flannery ruled against us, the preliminary subdivision plat of Stotler 2 is grandfathered and entitled to access to the public sanitary sewer system on the same basis as other developments approved in May of 2004. The parties acknowledge, and it says that PBM shall be authorized to use the sanitary sewer easements acquired, and it lists some property owners, and that's the last thing I want to talk about. So this grandfather is because it says the preliminary subdivision plat of Stotler 2 is grandfathered and entitled to public sanitary sewer. This is what the language says. But as I previously read a different provision to you, that expired in 2008, and they never did anything with Stotler 2. So one way to look at this is to say, if the preliminary plan from 05 expired in 08, then this preliminary plan, the 05 one I handed you, is no longer, and they have to come in and file a new one, which means they have to comply with our new subdivision regs, as Commissioner Jones points out, which are, very detailed now, which I don't think the developer has a problem with. They want to. But the rub is the other provision that you have to decide if that preliminary plan expired, thus this provision about them being entitled to sanitary sewer expired, then they can't build 371 units out there because there's no public sanitary sewer. And it's east of Zor Road, okay?
So just so I understand, so there's two definitive legal issues with this. Number one was this resolution by the commissioners, which I was a party to, that said you have 36 months to do anything. Because a lot of our language at that time was taking into account, it's not just that you had access to sewers, we're changing that. You would have had to have either filed a plat or done some sort of an improvement on your property to be eligible.
That's what this,
That's
that's what the
what we did back then.
resolution says, not just the court case.
Yeah, that's what we tried to do, have some justification of saying, we gotta cut the baby here somewhere, where are we gonna do it? And that was this reasonableness test, I guess, that we did back then. So then, that was not okay. Stotler 2 in particular, was subject to this other litigation at the time, through Judge Planner, or this other litigation, you can correct me. But part of that was Stotler 1 gets approved, and Stotler 2 is, you just have to do something now within 3 years of 2005, and then you're set forever. And you're saying the owner at that time didn't do anything. But yet, isn't there another ruling saying Stotler 2 is grandfathered in for everything, forever?
No.
Okay.
I think those two provisions go hand in hand. The first provision is what the RPC is agreeing to. And RPC says the Stotler 2 preliminary plat, as it was called then, has to be done in 36 months. Then the next paragraph in the settlement agreement is what the county commissioners in Warren County agrees to. And it says that in light of the court decision, the preliminary subdivision plat is grandfathered, and meaning you could have signed the plat and entitled to sanitary sewer on the same basis as other developments. But since the preliminary plan expired, then arguably it's a matter of interpretation. Then their the right to sewer expired. Now, the only other argument they might want to raise is, well, then you have your commissioner's resolution establishing the boundaries, and in the 05 resolution, it says that if a owner or developer has final and/or preliminary plat approval, well, they did, because the court said we hereby, that we order the planning commission to approve it. However, it expired after 3 years for Stotler 2, so that went away. And then the remaining conditions in it say, and have made improvements. Well, they haven't made any improvements. Nobody's done anything to Stotler 2. It's only now that the markets can come back and they're looking for land to develop that it came back. Chris's statement a minute ago where he showed you Wellington had preliminary plan approval. It had one stage, I think they might even had a final plat on, but the rest of their development that's contiguous to that, they had plans approvals on. They were east of Zoar Road, which meant they were beyond our line of demarcation, but they had preliminary plan approval, and it met the exception to the commissioner's resolution. Stotler 2 arguably had preliminary plan approval by the court ordering the planning commission to approve it about the same timeline frame this all happened, and that would have allowed them in, but they only had 3 years, and that went away. So even if you try to argue that this applies, that preliminary plan expired. So you understand now why Chris and I are here. Now let me tell you a few more things, because I want you to know everything. I don't want things to come up brought to your attention by someone else that you hadn't heard from us. Can you go back to the map?
I feel like it's Monday Night Football. We're going to the play.
This is like Bengals football.
I know it.
Missing field goal, missing field goal.
Where's your mic?
Got it, Madam Administrator. All right, you will remember, oh, actually, it's probably better on one of these. And you guys got mics up there, I assume.
Yeah.
Where's that drawing that I had moved here? No, I don't think it's on these. Where did I see that? Can you bring your maps up again?
Yes.
Let's see it. Yeah, go to the other one. And didn't you come up, yeah, maybe it won't.
Are you talking about the easement?
Yeah, I'm gonna get there. You got another map?
I got all kinds of that.
Yeah, go back to that first one. I'll just use it. Pardon me? I like the first one.
Me too. I can read it.
You, at least Commissioner Grossman and Young will remember that we had a couple of requests from a property owner with alphabetic letters. And on one of these maps I saw earlier this morning, it was on it. So it's going to be over in this area. This property owner has about 100 acres. And you might remember it was the Oder family, Bob Curran, at that time, a township trustee in Harlan Township. His wife was an Oder, and they all came in. And they asked the Board of County Commissioners, can we get sewers over here to develop this property? They also had property north of, or west of 22 and 3, back towards the village of South Lebanon. But they also had this one. This is the important one for today. County Commissioners said, we're not interested in changing the boundary, because they're saying, you know, what's the difference between there being sewer here and just bringing it under the road? And of course, back in 04, 05, it made a big difference after a legislative hearing. And the property owners asked, and the Board of County Commissioners said, we're not really interested, but we'll entertain what the preference of Hamilton Township is, their urban service boundary. They're not one and the same thing as a sewer improvement area. As you recently, as we talked about the organization that came before you just a week or two ago. And Hamilton Township came in and said, we do not want to expand our urban service boundary to the east side of Zor Road. We can't provide police, fire, snow and ice removal, paving, maintaining these roads. We just can't afford to do those things. And the county commissioner said no. They came back a second time. County commissioner said no. However, to revisit something that even dates 04, back in 03, before all this really hit the fan, we had Chris's predecessor, again, who was bringing stuff over to the county commissioners, and they were just signing off on it typically, who went out on his own, and he negotiated, because you had not only this area down here we've already talked about, but we had these other areas up here called Providence, and that's a substantial development up there, and that's a school, right? They donated land.
That they actually donate the land for the school.
Yeah, and Little Miami built a school here, and the rest is history. Chris's predecessor went out and he obtained easements that ran in this area of Providence, and easements. It did not run across this 100 acres. It came down here, but then it traverses, and I've got a picture for you, and I'm going to show it to you. It traverses this way, and it goes across this guy, the guy that filed the other lawsuit, and they filed it wrong, and we got it dismissed. In 03, got easements that ran across his property down this direction, or this far east, to come across into Stotler Tooth so that Stotler Tooth could be sewered. So nothing's built there, correct me if I'm wrong, but those easements exist. And let me show you a picture. That's my picture I'll show you that's better. Here's the 03. There's an 06 easement too, and I don't put much weight into it. But this is the 06 easement, and back in these days, we did them a little differently. This is my formatting. I signed it to approve it as to form, but in those days, we hadn't switched our process to where the board signed off. We started doing them sometime after that as agreements, and an easement, only the owner has to grant it to the grantee, but we do agreements because the Board of County Commissioners have certain responsibilities of spending money to not only acquire it, but maintain or or contribute certain improvements. And since you're spending money, I changed that format so the board had to sign them. The old days, the board didn't have to do that at this time. And here is a picture. Chris, come up here and look. Here's the 100 acres that I was talking about. It's ZFC. That came before you, this predecessor board, and they denied it a couple different times. That's the 100 acres. And then the easements, this is just a drawing of where the easements run, this easement. And it traverses over the Hildebrandt property, comes down and makes it down to Stotler's 171 acres. So if anybody's going to develop this, going to develop this, Stotler 2, they're going to have to construct an easement.
So, can you tell me again the time frame around when you had when the easement was granted for that?
03.
January 20.
So that was done prior to the
Boundaries changing.
boundaries changing?
Correct.
Okay.
Yeah. And this is something the board I don't know if the board ever saw this because the board didn't have to see it. It was just, they followed the format, and they brought it to the prosecutor's office. Since it followed the format, I approved it as to form, not necessarily substance. In 03, nobody's thinking about all this sort of stuff about our treatment plant having insufficient capacity, that we've approved all these massive amount of lots that we can't treat, which we can treat now because unless there's this other issue about collection line problems. But I wanted to show you that drawing. I thought is so helpful to see. And this is something that's been out there for a long time. And it was the Hildebrandt Family Partnership, and it was in Mark's dad's name at the time. But Mark Hildebrandt, who lives in Michigan, but born and raised in Hamilton Township, this was his property, and it was the Hildebrandt family that hired Voorhees, who filed this administrative appeal for some crazy reason, and we got it dismissed. But there's always been the concern in the back of my mind that what happens down the road someday when development comes back around and the Hildebrandts come to the Board of County Commissioners and say, we want sewers to develop our 100-plus acres. And you say, well, it's east of Zor Road, you're not in the area. And they say, but we granted the county an easement for $1 to run sewers across our property. That's a thing out there that I can't tell you how that's going to go, but it would be obviously an issue that we would have to deal with. So that's sort of.
The easement has been granted. There are certain conditions on that easement. It's only a certain width. I think the permanent easement, I believe, is only 20 foot wide. So the developer will have to figure out how to construct that sewer line within a tight easement area. He has no, I think the temporary easements, I think there's a permanent easement and a temporary easement with that. The permanent easement's 20 foot wide, it's in perpetuity. The temporary easement grants some additional space to build the line, but that expires after a certain amount of time. So that temporary easement has been expired.
But isn't that a legal question of, it's almost like a road? You know, I granted an easement, the county could have put a road across my property or whatever, and we never did it, but yet it's there. I mean, there's an easement there, but yet nothing actually was ever acted on, and it was not a administrative process. It was just a department head that went and did something.
That's an argument, but let me go back to the settlement again. The settlement under the County Commissioners, Warren County's section says, it goes on to say, and I mentioned it a minute ago, and now that I've talked about the Providence development back towards 22 and 3 was owned by the Lewis family, Mark Lewis and his family.
Who was that? Because I'm the one that actually negotiated that.
It eventually was Fisher. The developer is a guy that lived in Mason.
Yeah, he was a nice guy. I remember him.
Steve Wallace, that's exactly right. Built that subdivision that Judge Peeler lives in.
Yeah, because we were hammering him
it's
on
in
the
the city
school
of Mason.
problem, and he's like, well, they can build one here, I'll sell it to them cheap. I'm like, no, that's not good enough. They ended up donating the land.
So and I haven't touched on some of the other provisions I'll mention in the case as well to bring you up to speed, which, again, brings me back to this whole put it in context. At this provision where it says, you know, the preliminary subdivision plat of Stotler 2 is grandfathered and entitled to sanitary sewer, it then goes on to say, the parties acknowledge Stotler 1, and then it says, and that PBM shall be authorized to use the sanitary sewer easements to develop Stotler 2, and my position is within 36 months, acquired from Mark Lewis, Sylvia Stotler, and the Hildebrandt family to extend its sanitary sewer lines for Stotler 1 and Stotler 2. So I wanted you guys to know that that's out there. That's something we are going to have to deal with most likely. Now, let me finish this up and I'll sit down, and that is, it had a lot of other things in it too. And one of the things was it gave them what was called a RID, a Road Improvement District, where they could assess the property. Remember the one we did on 741? It came back around to you guys after the 07, 08 housing crisis. It went away. And then the States of Kiever Creek
Oh, that one.
Yeah, I
on
remember
741
you
across
talking
from
about
Oda.
that,
And remember,
yeah.
there was an assessment on it, and
That was their voluntary impact fee.
and that's what this is. And that's what this thing is. It gave, because we had done that one around this, well, maybe we did this one first. It was a statute that was available at the time, and it says they're entitled to do it by assessment project to the buyers of the lots, to improve Mounts Road in certain ways, including constructing a right turn lane onto northbound Zor Road. Well, that's no longer needed because when Wellington developed their sections, they realigned Mounts Road, so that one's no longer relevant. The other one that some of the calls that I fielded over the last year from civil engineers on behalf of developers that they didn't like was, because Mounts Road, as I referred to it as a goat trail, I mean, you had to pull over if you met somebody. You just couldn't pass. That's how bad it was. And in those days, and so you had to go from point A all the way up to point B to Stotler 2 on that little bitty road, and they were going to put 371 lots on it. The compromise was, per Neil Tunison's request, is that Mounts Road would be cul-de-saced. It would be cut in half. And there would be a cul-de-sac on this side and a cul-de-sac on this side where these folks could get out this direction. These folks of the new development would all go back this way. Well, part of Mounts Road is still very rural once you get beyond its new alignment, but the developers aren't interested, I think, in doing that because that's very costly to them. So in a lot of ways, a lot of the things that are in this agreed judgment entry, the developers don't want to do, including the approved preliminary plan, because Mr. Campbell and Mr. Birding submitted a revised preliminary plan changing the layout. And when I first heard that, I thought, well, maybe they made it better, maybe there's less lots. That's really not the case. It turns out to be less green space. The other thing they tried to do was they tried to bring in, when they filed this property here. Now, Stotler's owned this bowling alley lot that goes down to Foster Mainville Road. And we always thought they would try to bring it in so that they could have like a boulevard access here and do away with the need to have a lot of road improvements on Mounts Road. They didn't, but when Ken Campbell and Mr. Birding brought this in, they brought in, I think it's this farm, and they tried to file a revised preliminary plan for it. The rub was I had planning reject that because this property owned by a different property owner never had a preliminary plan approval. Nobody ever filed anything, and it had none whatsoever. So they were told, you can bring it in, but you got to go back and start, as you know, now you start through what's called the concept process. You bring a concept plan in, planning reviews it, comments on it, no action taken on it, then you can submit a preliminary plan. So this one came out, but it's going to be coming back. And, you know, obviously, if it had road access to Foster Mainville Road, that would be an improvement over utilizing Mounts Road. And it might be justification to say, well, why do we really need Do we need that cul-de-sac? That's a Neil Tennyson question. I shouldn't be commenting on that. But anyway, that happened. But again, why we're here is because this one got resubmitted standalone. And it's going to be on the RPC Executive Committee meeting agenda October 26th. Is that right? Something in that frame. And I wanted Chris and I to be able to get in front of you and talk about this somewhat before it, because Chris needs to write a letter and say, there's either sewer or there's not. And it's your call as to whether or not the boundary is applicable and it's east of the boundary, therefore there is no sewer, or it's, hey, there's this settlement agreement, and we think the settlement agreement still is applicable, so they are entitled to sewer, or not.
So essentially, they're trying to get half-acre lots? Or are they even half-acre? I mean, 170?
It's smaller than that, I believe. It's 100 acres.
I thought it was 170 acres, Stockler too.
171.
Okay.
171 acres with 56 acres of green space.
Okay.
You got a road network, so it probably nets out, like Chris says, somewhere around 100 acres.
Density is 2.17 units per acre.
So third of an acre, basically, something like that, right?
And remember, this is one where the township controls the zoning, the density of zoning, not you. You're only,
Well, why do they permit that density?
they do.
Okay,
Yes.
interesting. And then, so here's, I'm gonna just give you my quick takeaway.
Tom, if you could lean forward.
All right. So if this had been done within the 3-year period, they get sewers, correct? Within 3 years, they would get it.
Oh, yeah.
All right. Because your argument is that both the easement, which says that they can do it to get sewers there, and the agreement is a 3-year period. Beyond the 3 years, your point is that that ain't necessarily so.
Correct.
Okay. And we denied it to somebody else up there, but they're different because there's a lawsuit we were settling. Was the basis of the original lawsuit, does it still exist? Did they give away rights, or could they sue again?
Now, it had nothing to do with Stotler 2 making any claim that they were deprived of any vested rights in the property. That was not a basis. The basis was a challenge to the RPC denying the plat because they had no subdivision regulation of which they relied upon to deny the plat. And the judge says, if you don't, then you have no choice. You should have approved it, and I'm ordering you to approve it. That's all that lawsuit was about.
But how does that relate to sewers?
How it relates to sewers is that we settled the lawsuit because we were going to lose, and they were going to get this 371 lots down this little road. And we settled it, and we incorporated this provision in the settlement agreement that says that part of the consideration is we're going to give you sewers if you will agree to do certain things for us. And one of the concerns was we were concerned that if the court sua sponte, without sending it back to planning, would have just approved the plat as filed, because that's what the statute says, all the conditions are gone. There would have been no conditions. And that was one of the things that they gave us. They gave us some other things like cul-de-sacing the road, those sort of things. So it was, everyone benefited in some respect on each side to get this thing settled.
What is their argument going to be to get around the 3-year thing? Can they argue and say, look, the 3-year thing really wasn't all that material to the transaction, and that really that this was in perpetuity they get to do this, that this idea of having sewers on this area is not contingent on the 3 years as much as the 3 years was just to start something up, but they say, really, your agreement was to allow sewers on this property. period. End of story. And you can't get around that now. The 3 years wasn't like oh, we're being Santa Claus for 3 years to get sewers. I mean, it strikes me, it's a little bit strange how this thing worked out, and I haven't read the documents, but do they have an argument, Bruce, that says, look, the fundamental thing is that you were given us sewers here, and now you're saying, oh, no, we're only given 3 years of sewers. That after that, even though if you'd started anything, you'd had sewers forever in this location, but now you don't. And that, I mean, it just strikes me as strange.
Well, the current applicant for the preliminary plan wasn't involved in any of this. So they, maybe within the last year or two, when they started looking for land to develop, did they get involved in this? They were provided all these documents, even the easements. We provided them with everything. They didn't technically make a public records request, but Chris said, here's your hurdles that you have to get over. The only argument that I think I heard Ken made was, well, but the sewers are grandfathered. Well, that's not what this says. It says, in light of the court decision, the preliminary subdivision plat of Stotler 2 is grandfathered and entitled to access to public sanitary sewer system. But the other provision says, well, it's only good for 36 months. And I told more than one civil engineer for other developers who called me in the last year, I said, if you go in and you want to plat this 171 acres like the court order says, and you do every condition, you comply with every one of them, you're probably fine. But if you want to deviate from that in any way, I said, you're opening a can of worms where the county commissioners could say, you're not entitled to sewers.
Is that why they're submitting something that is so similar in terms of density as opposed to something less?
No, because it is I think it's just that, Ken and Greg, they do quality developments, and they looked at the way that was laid out, and they, I use the word hideous. I think that's probably their viewpoint too. And they submitted a revised preliminary plan. They're changing it. They're deviating from it. That's their proposal.
But that comment kind of confuses me, that you're telling them, if you come in and do exactly the way it was back then, you're probably okay, but yet that's not necessarily the case, because they still didn't comply with that 36-month.
I guess that's a fair assessment. Yeah, I wasn't thinking that way.
Yeah, because if the philosophy of the board is, we don't want that many houses there,
Correct.
legally, that is our argument.
Yeah, your point's well taken.
And just so everybody's clear, the commission got sued, but someone was sued individually because he went outside the boundaries of what was acceptable denial. It was kind of his feelings, and he was talking more about the schools than the law, and.
Correct.
I mean, if I remember correctly.
If you ever want to read something that's interesting, and the court decision the magistrate made, typical Andy Hasselbeck, very detailed and lengthy, but the decision of Judge Flannery is not your typical judicial decision. It's not about, here's what this statute says and here's what this case law says. It's him pontificating about where Warren County is located between Dayton and Cincinnati, and the demands, how they've grown out, and the demands for residential housing have overburdened Warren County, including the school system. And the very last thing he says, and it actually might have been Hasselbeck that said it, but it related to that. It says it's what the Planning Commission was trying to do was well-founded. They're going to overpopulate the largest school district in Warren County, who's can't make it already.
Already in financial crisis.
Yeah, already in fiscal emergency with the state auditor's office. But nevertheless, the law is the law, and the rules of the game are you follow the subdivision regs, and there's no subdivision reg that says you have a basis to deny this, nor did you cite one. So therefore, I have no choice but to do this. Misuse of the subdivision regulation rules is not the proper by means which to slow or even stop current pace of growth, unfortunately, is what he said. The court has no choice but to sustain the decision of the magistrate and overrule the objections of the defendant. It's an interesting read, the way he pontificates all of this. But again, both the magistrate and Judge Flannery's decision were all about the subdivision regulations, that's all.
Yeah, they're saying philosophically, they agreed with what the board was trying to do. They just didn't do it using the rules correctly.
But if those were approved, why were they entitled to sewers if it was outside of our sewer boundary?
Because the density that they were proposing, obviously, under.
Required sewers.
It required sewers, and they wanted sewers.
And they were initially in the boundary area before it was changed.
I don't know if they were in Stotler 2. I'm not sure they were initially in the boundary area. I don't recall that.
I don't know, I have to look at a map.
Well, I'd like to know that.
But they had us on the ropes. You know, they were gonna get this plat approved with not a single condition required.
Because they had a
potentially.
plat approval.
Okay, so.
That's what it was. It wasn't they were in the improvement area. They had already a preliminary plat approval.
Yeah, well, once the court said you shall
Well,
approve it.
what made them different than everybody else? That's what I'm. Versus Hildebrand or anyone else, why?
They had a plan,
They had a preliminary plan that the court approved. And we were appealing with very weak grounds to appeal, and they were gonna get their sewers.
Because we made a lot of changes once their plan was already in place?
No, their plan came in '04, the litigation went on after that, and they would have fallen under our exception in the boundary resolution because they had an approved preliminary plan per the court order. So they would have fallen under that, and they would have been in. That,
I think you have questions on timing of the sewer boundary. This lawsuit, correct me if I'm wrong, Bruce, but this lawsuit went through, and then shortly after that, the county commission revised the sewer service boundary and pulled it back.
He's
Is
got
that the
one.
proper timing?
the original commissioner's resolution was in '04. The lawsuit was in '04. The exception resolution saying if you have preliminary plan approval was in '05. And we knew, the reason that got put in there was we did not, the Board of County Commissioners did not want to deprive someone of a vested right. And we felt like that they had a vested right if they had preliminary plan approval. But I had forgotten until recently that I put this language in that said, if you have relied upon it, some detrimental reliance, and then you have made improvements.
Right, three parts to that.
And it wasn't a matter of first impression for a developer in Warren County to say, you know what, our time is going to expire. It happened on the Grove property in Turner Creek Township.
Right.
And they came in and platted one lot so that they were locked
Locked
in,
in.
so that the sunset provision was moot. They did that. They didn't have a plan. They weren't going to construct, but they platted a lot, and we saw no way to say you can't do that. And once they platted that one lot on the Grove property, their timeline was moot. Here, that never happened because the whole housing industry just went dead. And nobody was interested in developing that. And they were still, you know, developers, you see them approve 171 acres here and 65 acres there. They don't go all plat these whole
So
things.
what happened
They
to
do
the
it in
people
phases.
what happened to the people who had that approval to go forward? Where did they go? Did they sell to?
Yes.
Somebody that sold to Ken Campbell and Birding? Who?
I think it changed hands two or
Multiple
three different
times?
times, yeah.
So at the time that the current people bought it, they knew about all these documents, didn't they? They knew about all these decisions.
It's a
And they-
public record.
Okay, and I know they've got to have a good lawyer. Who's their lawyer?
When all the litigation happened, it
No,
was
no,
Joe.
I'm talking about who's representing Ken Campbell in this?
Right
program?
now,
Yeah, do we know?
Mr.
No,
Hunt?
but Fisher's typically represented by Steve Hunt and Rick Palo. Typically, yeah. But you've hit something there. when they bought it, and I don't know that they bought it yet. No, I
Might
know
be
they
under
haven't bought it.
contracted.
No, there's some entity, some person up on Hart Road that I never heard of. I looked her up. I wrote it on your documents there that I gave you. She owns it, and I'm sure they just have a contract to purchase with conditions in it, due diligence conditions or an option to purchase, so they don't own it yet. But when whomever bought it from and I'm not sure PBM, they were just the developers. Stotler's were the owners. When Stotler sold it to the next owner, who sold it to the next owner, each time there would have been, good lawyers involved, there would have been title work done, maybe even title insurance. And the decision was filed with the court, so a title abstract would have, because we used parcel numbers, I did, when I wrote this stuff. And so the court decision is a public record. It would have been
You know, see,
reported on
that's
the
my
title
question.
exam.
So that's my question. My question is, what notice of this stuff do they have? And so they're looking at it, they got good lawyers, so when they're buying this property, they know, and I like to see what kind of judgment they're making though, so they're thinking, okay, I got sewers, well, maybe I don't,
And they're the epitome of sophisticated investors.
That's what I'm wondering
That's-
about, yeah.
They should know better than anyone. These are all the things that you have to jump through these hoops.
And I think that's what they're doing here,
Right,
putting
that's
forth a
why they
preliminary
put
plan. They're
same number of
testing the
lots.
waters.
Yeah,
They're gonna find that out.
they're trying to come as close to the original plan as they can in every way so that they can say, you see, I'm doing the original plan, I deserve the original approvals from which there was a settlement. Because I'm not going on the, I got 3 years to do the thing for sewers, I'm doing the original plan approval.
Is grandfathered forever, no matter
Exactly,
what.
and I'm gonna drive that truck as far as I can.
You know what? I think I agree with you. That's probably rare.
That's what they're doing.
I think you're probably right, because when I heard that Ken was involved in this and Greg Birding, I was expecting to see some preliminary plan that really had a nice, attractive community. And that's not what they
But 100%. So here's where I mean, we can keep, number one, I want to make a statement. I am so glad you're here, Bruce. This is the definition of institutional knowledge that's just so critical. Number two, Adam, I'm glad you're here because Bruce might not always be here. And I think these are so
He's getting
critical. Right. This stuff is so critical, having people with the knowledge. I think this is the definition of succession planning, even though Bruce is too young, I'm not throwing him out the door. But it's good that people in that office understand this stuff because this is critical. And when I keep going back and talking about this stuff, this is all I lived with. My first however many years, 3 years in office, this was it 100% of the time. 150 people in the room every time we talked about this, Bruce, just literally tar and pitchforks. I mean, this was it, period. There was no other issue in Warren County for most people other than what we're talking about right now. So that's why I am so hypersensitive to adjusting that sewer boundary ever, because I know that's what, it's the demarcation line. You do it once, we might as well just let quarter-acre developments go everywhere in Hamilton Township, and we're going to be right back in the situation we were in 2003, 4, and 5, when literally it nearly bankrupted the township, services went down the tubes, and the schools were bankrupt. Those are facts. That's not even an opinion. Those are, Bruce, correct? Those are facts. So now we're presented with an excellent history of the situation. Here are the two views. I want no houses on Stotler 2. That is not my position. I want 374 houses crammed in less than a third of an acre lot on Stotler 2. I do not want that. So I think I'm comfortable saying our official position is you don't have sewers here, according to this agreement, and then they're going to come back and try to negotiate. Well, and then it becomes a negotiation. What is the board comfortable with? Because I don't want to see that. I mean, you're putting lipstick on a pig. It's still basically the same density. It's slightly better plan, but if they're only doing it on that many acres, you're still jamming these small lots on top of each other.
But do we have control over the density?
Well, and that's the
It's
thing,
already
I'm
in
not
place.
comfortable using our public utility as a way to control. It's the same question we've had before us before, as a way to dictate the density that's outside of our right to dictate the density. But I do think that there's a case to be made that we're not in any obligation to provide the sewer because the time had elapsed, the boundaries have changed, and a plat was not filed of any, meaning. But I certainly wouldn't want to be in a position to say that I'm not for sewer because I don't like the density, because I don't think that's government's right to dictate it in that way.
Hamilton Township would not want you to, if that helps you, if you were to send them a letter, they would not want you to sewer this.
See,
But they don't have any say in it if they're not changing the zoning. The
Right.
zoning's already in place.
Yeah, and the thing is, but I'm wondering, okay, so clearly their smart lawyers have got to have looked at this, and they've decided that we can drive the same truck that drove that agreement by saying there's been a plan approval for this type of development, and we're basically doing exactly everything we can to make it fit within that structure and say, voila, it's a bad pig, but it's the same bad pig as before, and we have the right to the sewers because all we had to do is produce the same stupid pig we had before to get the sewers. And so I'm wondering, is it possible for us to say, okay, we've got some risk in that argument, and maybe can we get them to say, okay, can we get a way less dense or way better plan, and we'll give you the sewers? Can we do that?
You sound like Commissioner Young, which I forgot to give credence to. There was an impact fee donation in that agreement of $750 per lot to the school district,
That's a
in that
condition.
agreement as well. I just wanted to point that out.
Well, I mean, I don't know what, frankly, just sitting here with all this stuff that's come at me today, I'm not exactly sure how to maneuver on this. It's almost like I gotta sleep on this sucker. And if we got a meeting on Thursday, I'd like to address it again, but I wanna think about this thing. Because I'm really uncertain. I'm uncertain of how to philosophically work through what I was just fed.
Well, you got a couple of weeks before the RPC executive
Okay,
committee
well, I'm
meeting.
glad I do, because this was an awful lot to be thrown at somebody like me who's thinking very legally about this. Because I would have answered it the same way as the people we dealt with above, to be consistent, but this is a whole different kettle of fish.
It is different. It is different.
RPC will take action at this at the end of the month, I think it is,
I
scheduled?
think it's the
26th.
26th.
Which is why I'm not concerned about doing some sort of negotiation, because I don't think we're changing any boundaries here. This is different,
Yeah, yeah.
so, right? So
Yeah,
anybody-
I agree. I think that's a good approach, to see if we could negotiate something, and I'd be talking to those folks.
See, I mean, I wanna sleep on it, but I'm thinking, okay, this is not the normal Ken Campbell development. He's and his people are looking at it and they're saying, we gotta squeeze this
Yep.
thing into that original
We got a
plan
home run
approval, and then we're gonna get it, and we don't like it, but baby doll, this is how you make money. So, and I'd rather say, hey, okay, we see where you're coming from, but let's see if we can find something else that's a win-win for everybody.
But that's exactly my point. We can either fight and say absolutely no, which I think is kind of our position to begin with, but we're okay with something going there.
Right.
Which is again, that is just the way I think.
Well, I think we gotta be okay with something going there with sewers.
Yeah, yes, yeah,
And-
I am.
Exactly.
Yeah, that's what I mean. But this is our opportunity. I'm sorry, I know I'm different from you guys a little bit, but this is the way I think our role in controlling too much density in this one area, which was literally the fastest growing township in the entire state. And when it gets going, it's let it rip here.
Yeah, I totally appreciate that point of view, but Hamilton Township controls its own zoning, and they zoned it for that density.
They screwed up. We have all sorts of political subdivisions, i.e. King's School Board, that screws up here. before us, and sometimes we have to act a little bit like Big Brother and think about these things.
Well, I agree with Shannon on that. I mean, I completely agree with Shannon. I don't like using sewer for zoning purposes. But at the same time, this is such an unusual fact pattern, that I'm just kind of throwing the rule book out with this thing. I mean, I really don't, but it's too complicated for me to give it a legal fine point right now.
Well, and I'm certainly cognizant of what you're bringing in terms of the 2003 filing of the utility easement, the sewer easement in that property that's north of that Haynes or
Hildebrandt.
Hildebrandt property. I mean, this is, we do something different, even negotiated around this Stotler 2 property. There is going to be, we're going to see this come back to us.
Yeah, typically I get a question from the other end of the bench about, tell us what the unforeseen consequences are. The unforeseen consequences definitely will be that the only way they get sewer to Stotler 2 is to utilize that sewer from 03 across Hildebrandt that runs across his property that he donated to Warren County. And even though he doesn't have a preliminary plan approval, he didn't detrimentally rely on anything, he didn't do anything other than he gave us an easement, the next person is going to be asking you is him saying, well, Stotler's now built this sewer across my property, and which he has a right to do if you let this go forward, and there's another 100 acres that are coming in.
Right.
But I don't know how that opens you up to, obligating to the county to build, to allow sewer development on that. I mean, it's an agreement, an easement. It's not,
Well, but
there's
what
no
he's saying is,
obligation.
an easement is not a simple exchange of property. He's saying that I've got sewers on my land. I simply gave you permission to put that thing on my land, and now you're telling me I
don't
can't use the
take
sewer
advantage
on
of
my
it.
land?
That's right, because the sewer's gonna be run
And
Yeah, I
the-
mean,
But-
it's gonna be on
to
his
serve the
property.
Stotler
He only-
Stotler 2
he's only-
property.
He's only giving you a use agreement.
Do you think, are there sewers down on, what is that, Foster's Mainville?
No, there's no sewers down at that location.
And that property to the south, which
Acorn,
is.
on Acorn Drive down through there, we have sewers, but nothing down on Foster Mainville Road.
The property, Commissioner Young, south of what's delineated as Stotler 2, and I mentioned it, it's owned by a company or LLC called ABT that Ken and Greg Burling want to bring in. They tried to bring it
But
together.
I'm thinking, are they gonna go that way with the sewer?
No, they won't go that way with the sewer, but I will let you know their density on that, because they, in essence, concede it's outside the sewer district, I think was only like 1 unit per acre, although I guess they'd have to have sewer for 1 unit to the acre, but it certainly isn't 2.1. It
So
was
you're
only,
you're thinking they're looking at on-site systems at that location?
if they could meet.
No, they're gonna tie in, the 100%, they'll come back in.
Well, they can't. They're outside, that one's a black and white, you can't get sanitary
The only
sewer
way
on
they
that
could
one.
do that, I mean, physically, is that they would have to build a pump station and pump it back up. So, I mean, but what you're saying, the density is more in line with the home sewage treatment system.
Yeah, they submitted a different, separate plan, and I think it may have already been filed with planning too, and the density on it is not very high. It's not like this. The other thing I would point out, in when Mr. Browse wants to debate me, it does say in the settlement agreement, and this is the section where the Board of County Commissioners and Warren County agrees, and again, not, 3-year preliminary plan, but PBM as the developer is authorized to use the sanitary sewer acquired from Mark Lewis, Hildebrandt, and Stotler. So it was an agreement, you can use it. Chris is saying, well, there's no guarantee someone has a right to use a sewer granted to us. We agreed to it in this, assuming the three-year contingency.
No, I agree. Yeah, that's a
Yeah,
problem.
you're right.
different.
So essentially, if we do it here and say it is outside the norm, I think, again, I'm always comfortable raising my right hand of, hey, this is why I did something or whatever. If someone has literally sewer on their property and I'm not allowed to tie into it, the judge asks, you think that's reasonable? I don't know that I can say, no, it's not reasonable. If the sewer's on my property, you're telling me I can't tie into it?
Yeah, and one more thing I'll point out, this is still different than what you heard recently with St. Zachary's Haven.
I agree.
In that, this doesn't open up a big area.
Yeah.
All it opens up is certain area, and the Lewis property is Providence. It's already developed, it has sewers. The only one that it opens up is Stotler, and other than Stotler would be the Mark Hildebrand property. That sewer.
So it would come right off of that in line there in Stotler 1 and cross into Hildebrand only? Is that what you're saying? But there's another parcel, that Hourglass parcel, just to the left of Stotler 2.
There is, but.
That recently came through planning with a plat for that. So Mark Hildebrand submitted that for final plat approval. And so that should have come through. I don't know if that came through commissioners or not.
So that's.
No, it didn't.
So
Didn't
the-
you tell Mark you didn't, that you didn't have to sign off on it because there's no sanitary sewer?
Right, we have no sanitary sewer.
So it must be at a density. with
So it's a
on-site
septic
system.
system.
It's
that's going in
on-site
Yeah.
system.
So Mark is subdividing some of his land, but not under RPC regs, because there's no,
Okay, well, stuff to think about, but yeah, I mean, because again, we keep going back to the settlement, but in some ways, at some point, we have to make the determination. The settlement's moot, doesn't matter. You didn't comply with the settlement, doesn't matter about the settlement. If that's our position, which is a legal if we try to do this hybrid of, well, you had a settlement, we can fight you on it, so we don't like your plan now, so can we play nice in the sandbox together, is a reasonable alternative, but yet your point is well taken. That means at least one property, and I gotta look at that again, at least one property now is gonna essentially say the same thing. I've got sewers. What do you mean I'm not in the area?
yeah, if he wants to go that route. I mean, he just came in with his other land and he went, with on-site
On-site
systems.
Right.
All right.
What, can I ask when you would like to discuss this again? So next Tuesday,
Yeah, I'd like to
we are
discuss it again
in,
next
we are
week.
in Washington DC, so
All right.
Shannon will not be here next Tuesday.
Doesn't have to
The
be
following Tuesday is packed to the rim.
Well, I'm happy to address it again next Tuesday, but I want time to think about it and then maybe talk to you about that I really don't know. This has been almost as much fun as getting locked into the jail today. So, boy,
Eventful day.
yeah,
So is my direction to reschedule them for next week then?
yeah, do that, please.
Is it time sensitive? What is?
Is it time sensitive? No?
What's the end
No,
of the
even the
month?
26th isn't a drop-dead deadline,
Okay, well
because
then
they're probably
then
gonna
let's do
follow
it
my
when
advice.
Shannon's back and do it at a time when it's not so busy.
Okay,
Say that
then the
again,
following week.
say that again, Bruce?
It's not that time-sensitive, except for Chris being able to issue his letter. That would be time-sensitive by the 26th. But RPC will probably follow my advice, and staff will recommend approval subject to conditions, including one being that the Board of County Commissioners allow sanitary sewer.
Yeah.
I think our position, what I'm comfortable saying right this second, and again, if we amend this, would be, we're looking at the agreement, and that agreement had a 3-year sunset. Our position right this second, unless we're convinced otherwise, is it doesn't have sewers.
Well, I'm not comfortable making any decision about this right now.
Okay, well, if you go this route, that takes you to the negotiation table. If you take a position that, to the contrary, then there's no reason for the developer to negotiate with you.
I think that's our only move. If something has to be, you have a drop dead date of responding in a letter form?
He
What's
can
this
respond the morning of the 26th.
The 28th is the Thursday.
Sorry.
28th.
26th is the
Planning
meeting
commission's
date.
on the 28th.
Okay.
And you're saying the 26th, we can't do it?
We could, if you want to make it fit, we'll make it fit.
Yeah, we can just do it after the lunch. We've got a lunch and do it then. I mean, it's important. We have to do it.
After, just schedule him after your elected officials lunch.
Yeah, we,
Sounds good.
If you want to do that.
Everybody good with that?
Yeah, sure.
Okay.
That
All right,
works.
good.
thank you. Very
Motion to
educational.
adjourn?
And yes.
you off.